All right, Crim 1, here we go with Chapter 9, Pretrial and Trial. So I want to point out the obviousness, or maybe not so obviousness, of the word pretrial. So pretrial is simply that. It is before the trial. So the trial is a time when the prosecution is trying to prove beyond a reasonable doubt that a person is guilty by presenting evidence, witnesses, things like that. So that's the actual trial part, but this chapter talks about before the trial and the trial. All right, so pretrial just means before trial. Well, let's go. Here we go. Okay, so defendants clearly have rights in court. One of those being the right to, a lot of people would consider right to bail the proper phrase. I wouldn't call it that. We have the right to be considered for bail. And bail is a sum of money deposited by the defendant with the court to ensure that the defendant will appear at their trial. So basically you pay a certain amount of money. Generally speaking, it's 10% of whatever the bail amount is, and you are able to be released from custody and you are out on bail. So there's a lot of benefits, pros and cons to bail. Pros being, if you are trying to work on your own case, to present your own defense or to assist in your own defense, is a lot easier if you are out of custody than it is if you are in jail. So that's a benefit of bail. It's also a benefit in that some people who get arrested actually work and they are supporting themselves. So if they are locked up and in custody, they are not earning any money. They may be losing their job. Their job might have been the one thing that was keeping them from becoming a habitual criminal. So keeping them employed, they're paying for themselves, they're supporting their families, things like that. Those are other positives. And then maintaining relationships with families, especially if they have children. Being in custody, dad or mom being locked up in jail, it impacts the family as well. Now, if they're out running around committing all kinds of other crimes, then obviously bail is not necessarily a positive thing. But so the Eighth Amendment says that excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishment imposed. So bail has to be, in air quotes, I would say, reasonable. In my personal opinion, I think bail is inherently unfair. A lot of people would say if you can't afford to bail yourself out of jail, then maybe you shouldn't commit the crimes. I don't know, but if even a college student, for example, who is working at, let's say, Starbucks, gets arrested with me, and I'm a professor at a community college, who's more likely to have the money to be bailed out of jail? I mean, it's very likely going to be the person that has more money. So obviously that's kind of inherently unfair. Something that's being worked on in California, and not sure what the answer is, to be honest, but that's bail. So do we have a right to be released on bail? No, but we do have the right to be considered for bail. What are some reasons a judge might not release us on bail? There's two reasons I can think of. A flight, meaning you're a flight risk, meaning that you wouldn't come back to court and they would never see you again, or you're a danger to the community. So if I'm a serial killer, they're probably not going to release me on bail. The Sixth Amendment. Okay, I'm going to read through this. All criminal prosecutions, we have the right to a speedy trial. And we'll talk a little bit more about this later. My dogs are fighting behind me, so sorry if there's weird noises coming from there. We have a right to a public trial, meaning that people can come in and watch. We have the right to an impartial jury. What else? We have the right to call our own witnesses. We have the right to face witnesses against us. And we have the right to have an attorney or assistance of counsel. Right to counsel, right to a speedy trial, right to jury. Let me clarify here. You do not have to have a jury trial if you are a defendant in court. You can have what's called a bench trial, meaning you'd ask the judge to make all the decisions on behalf of your case. Your guilt or innocence will be decided by a judge. There are certain times when that's beneficial. I would say in cases that are especially disturbing, like sex offenses and things like that, you never know what people in the jury are, or how they're going to respond to something disturbing like that. Judges generally have, unfortunately or fortunately, they've heard a lot and they've seen a lot. So they're not always as caught up and concerned about the nature of the offense if it's something serious. Oh my gosh, loudest car ever driving by, and my dog's fighting in the background. Okay, so change of venue. All right, so a venue is just the geographic location of the court. So in some instances, oh, now my phone is going to ding too. Great. This is kind of a circus over at my house right now. So anyways, excuse me. Change of venue. So let's say there was a case and the victim in the case was, let's say oh, good Lord, the car is coming back again. Are you kidding me? The victim in the case was, let's say, the husband of the mayor of a small town. Everybody in that town knows that victim. And everybody in that town is probably going to have read news stories about that case because the victim was somebody that everybody knew. Let's say they knew and loved that person. So when they go to court, the defendant could argue that it's almost impossible to get a fair trial in that location because the people in the community that might be in the jury pool already know too much about that case. So they might ask for a change of venue, which means moving the case to a different location. This happened, I think, in the Scott Peterson case. If you're familiar with that one, he murdered his pregnant wife. It was up in the Bay Area. And while she was missing, there had been news conferences, flyers, all kinds of stuff. So it was a really, the publicity in that case was next level. There was everybody knew who Lacey Peterson was. So they asked to have that case moved to a different location, a different venue. And I believe they did. If I remember correctly, it went to Mariposa County. He was still convicted, but anyways, in his case is still ongoing, long story. But anyways, you have the right to confront and cross-examine witnesses. Hearsay. So when you hear the word hearsay, most of you will probably attribute that to gossip or something that someone heard from someone else. And that's exactly what it is. Hearsay is evidence, which is usually excluded from court, that does not come from the actual person themselves. So let me give an example. I'm actually going to give you an example of one that's an exception to the rule. But let's say I get shot and one of my students runs into the classroom and I'm still breathing and I look up at that student and I say, Johnny did it. And then I die. So when that student is called to testify in court, when they testify to the fact that I said Johnny did it, that would be hearsay because he heard me say it. That means it is hearsay. It's not something that he saw with his own eyes. I hope that kind of makes sense. Anyways, double jeopardy. Double jeopardy means that we cannot be tried for the same crime twice. And the word tried is important. You can be charged with the same crime twice, but you can't be tried for the same crime twice. All right, double jeopardy. So once there's an acquittal or a finding in a case, you're found not guilty. It's too bad, so sad. That case will not be heard again, even if new evidence comes up. Think O.J. Simpson. So what if, for example, now he decided he wanted to do an interview with Oprah because he's broke, and he comes forward and says, yeah, I killed her. I killed Nicole Brown Simpson, and I killed Ron Goldman. Can they charge him with that? Nope, double jeopardy. He's already been found not guilty of both of those crimes. So, pretrial process. What happens first? A person is arrested. Then they're booked, generally speaking. Where are they booked? Usually at the Fresno County Jail or in jail. At that point, the district attorney's office reads the police report and they decide whether or not to file charges. That is what the criminal complaint is. Those are the charges against someone. Then the court process begins. At the arraignment hearing, which is generally speaking the first hearing, there are quite a few things that could happen. You could enter a plea at that hearing. Your bail amount is usually set. You probably, unless you've hired your own attorney, will probably be meeting your attorney at that hearing. You have the right to have charges, all the charges read out loud in court by the judge. So most people will waive that right and say, I can read it myself, but you have the right to have those charges read to you. And reciprocal discovery is usually ordered. That means that both sides are responsible for sharing all of their evidence with each other. So if I'm a prosecutor, I got to give the defense team all of my evidence. And if I'm a defense attorney, I have to give the prosecutor all of my evidence. Reciprocal discovery. Oh, is that car coming back again? Oh, yes, it is. It's a little red Mustang, like old school Mustang. Anyways, probable cause hearing. These two types of hearings right here that are listed, grand jury hearing or indictment and preliminary hearing, those are both, they're two different ways of doing the same thing. A grand jury, if they issue an indictment, that means that they have found that there's enough evidence to go forward with a trial. Okay, so they will hear evidence put on by the prosecutor, and they will decide if there's enough evidence for a trial. And then they're done. That's what the grand jury does. Preliminary hearing is really pretty similar, although it's a judge that hears basically a mini trial, a little snippet of what's going to happen in the actual trial. And when the judge hears that evidence, he or she will decide whether or not there's enough evidence to go forward with an actual trial. So that in a preliminary hearing, grand jury indictment, those are generally the same thing. They do the same thing. They're different ways of doing the same thing. There are lots of motions that can be made before the court pre-trial. A motion is basically a request for something to happen, and so they can be in writing or they can be oral motions. So just some examples, a motion for severance. Let's use this example. I am a law-abiding citizen, look relatively normal, and have no criminal background, and I get arrested with my husband, who, and this is not true, by the way, who is a tatted up bulldog gang member, and he has F the world on his forehead, and he has a bunch of other tattoos, and his head is shaved, and he's got BD on his cheeks, and he looks really like a bad guy. But we got arrested together, and I don't want to go to trial with him because I'm going to look bad because I have to sit next to him, and people will know that I was with him, so they're going to automatically think I'm guilty. So I'm going to ask the judge to separate our trials, and I'm going to make a motion for severance. I hope that makes sense. You can make a motion to exclude evidence. If evidence was obtained illegally, then it is up to the defense attorney to make a motion or a request to exclude that illegally obtained evidence. There can be a motion for competency. Competency is addressing whether or not the defendant at the time of trial is competent, is able to understand the court proceedings and assist in his or her own defense. And then there can be a motion for continuance. This one is a tricky one because defense attorneys really can ask for cases to be continued for long periods of time. However, prosecutors don't have that same privilege. Why? Well, because I told you a couple slides ago that we have a right to a speedy trial. So prosecutors, basically the DA's office, they have to be ready to go when the time frame is up. They cannot ask for a continuance if they're butted up against one of the deadlines. However, a defense attorney can just ask their client, hey, I need some more time to work on your case. Is it okay with you if we continue this for 2 weeks and you stay in custody while I work on your case? The defendant's probably going to say yes. So that's a motion for a continuance. Plea bargaining. Agreement between the prosecution and defense in which defendant pleads guilty to something in exchange for something else. Now, this could be, it could be a felony vehicle theft charge was filed against me, and in order to get me to plead out as opposed to take it to trial, the prosecution might say, hey, we'll reduce this to a misdemeanor if you will plead guilty, and then we're all done. Other instances, maybe I was out vandalizing, I smashed 30 car windows, so I got charged with 30 counts of misdemeanor vandalism. So instead of having to go to trial and prove beyond a reasonable doubt that I smashed all 30 of those windows, prosecutor might say something like, how about you plead guilty to 3 of them and I'll dismiss all the others. What is this guy doing? He's driving back and forth. And then I'll dismiss all the others. So that's an example of a plea bargain. Another one, think murder, first-degree murder, and the death penalty is a possible consequence. So a way to make someone potentially plead guilty to the murder would be to say, if you plead guilty to murder, I will take the death penalty off the table, meaning you won't get death. So yes, they are controversial, but very necessary. A very small percentage of cases actually go to trial. The vast majority, and I'm talking 95+% of cases, are resolved by way of a plea bargain. The courts would simply crumble if the prosecution had to prove beyond a reasonable doubt every case that they filed. So I call it a necessary evil, but it is part of the deal. Okay, then the criminal trial. Now we're on to the trial where the prosecutor is tasked with proving beyond a reasonable doubt that the defendant is guilty. The prosecution is always has the burden of proof. They are responsible to prove beyond a reasonable doubt that a person is guilty. The defendant doesn't have to do anything. So the burden of proof is always with the prosecution, and it is beyond a reasonable doubt. That's a tough one to describe, to explain. What's reasonable? You know, it's up to every single juror. So it's a tough one. Beyond a reasonable doubt. So you got to be pretty stinking sure. These are the stages of the trial. Jury selection. Once the jury is chosen, then the court may decide to sequester that jury. What does that mean? That means that the jury has to be kept away from the public during the entire time of the trial. That means that they stay in a hotel. That means that they have limited access to their phones. And that means that they are basically, I don't want to say prisoners because they're not really prisoners, but they're taken away from society so that they don't hear any media coverage about the case. So that doesn't happen very often, but it does occasionally. Opening statements. This is when each side, prosecution and defense, will give their version of the story. They are kind of laying out what they're going to prove to the jurors. Then the prosecution will start their case in chief, meaning they will present evidence and witnesses and, hopefully for them, prove that the defendant is guilty of whatever crime they've been charged with. They will do direct examination and cross-examination. Direct examination is when a witness who was subpoenaed by the prosecution. Let me see how I can explain this better. Hold on. All right, each side will subpoena witnesses on their behalf, prosecution and defense. When a prosecutor is examining or questioning one of the witnesses that the prosecution, subpoenaed, that is called a direct examination. When the prosecution is examining or questioning someone that was subpoenaed by the defense team, that is called cross-examination, and vice versa. I hope that makes sense. At the end of the prosecution's case in chief, the defense team can ask for what's called a directed verdict. And basically, that is when the defense team says, we've heard all the prosecution's evidence and they have not proven beyond a reasonable doubt this crime. And sometimes the judge will say, you're right, and they'll dismiss the case. Usually that's not what happens, but it could happen. And then the defense team goes, and they have their opportunity to present their evidence to prove that their person did not commit the crime. Rebuttal is both sides going back and forth and presenting their responses. And then a closing statement is generally, I call it, they kind of wrap it up, tie it up with a bow, and tell everybody, the jurors, this is what we've just proved to you, and this is what we think you should find. Then the jury gets the case. The jury will deliberate or sit in a room together and talk about the case. And this is the first time that they've talked about the case, by the way. Like I said, I was on a jury, and it was an 8-day trial. During the 8 days, we were not allowed to talk about the trial. And we spent a lot of time together, but we could not talk about the trial until it was deliberations time. So, excuse me, sometimes a jury can't come to a unanimous decision on a case. They can't all agree that a person is guilty or not guilty. If that happens, it is called a hung jury, and a mistrial is ordered. After a mistrial, the prosecution can choose to file charges again and retry the whole case, or they can choose to dismiss. Now, this happened in the Bill Cosby case. Sorry, yeah, my brain turned off for a second. This happened in the Bill Cosby case. He was tried for the rape of I think it was a college basketball coach. And during the first trial, the jury deliberated, and they were a hung jury. They could not come to a unanimous decision. So probably a year or two later, the prosecution tried the case again, and he was convicted the second time. Now, is that double jeopardy? It's not, because there was no finding the first time. So he was not found guilty or not guilty the first time. It was just a hung jury and a mistrial. Okay, bifurcated trial. Okay, so there's only one instance when a jury will actually participate in the sentencing portion of a hearing, and that is during a death penalty case or in a capital case. So a jury in a death penalty case will hear the circumstances of the offense and decide whether or not the defendant is guilty or not guilty. If they decide that he or she is guilty, then they'll go to the death penalty phase, and that the jury will also hear that portion and make a decision as to whether the person will be put to death or get life without parole. So hopefully that makes sense. In any other case, as soon as there's a conviction or a true finding, a finding of guilt, then the jury's done. They don't have anything to do with sentencing. But in a bifurcated trial, where the death penalty is an issue during a capital crime, there are two sections to their job. Ooh, wrong way. No. This way. There we go. And this is just kind of I thought this was a good kind of flow chart that shows the criminal justice process. Arrest, arraignment, and there's all kinds of different options of things that could happen, and all the way to sentence. So just something for you to look at. So that is it. On to the next.